Hello everyone, my name is Camille Agnello and I am the Higher Education Title IX attorney at Rocky Mountain Victim Law Center. Title IX is a federal statute providing that, quote, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance, end quote. If you would like to learn more about Title IX and the previous guidance, please refer to our past video series done by our K-12 Title IX attorney, Alexis King, called Getting to Know Title IX. Last month, the U.S. Department of Education, led by Education Secretary Betsy DeVos, announced new Title IX federal regulations outlined in a 2,033-page document. These new regulations are set to go into effect August 14, 2020. And are legally binding on nearly all K-12 school districts and institutions of higher education. Although we are still reviewing the document for nuanced and detailed changes, I would like to briefly overview 3 of the many significant changes contained in the new regulations. First, the definition of sexual harassment has been narrowed to mean unwelcome conduct that is so severe, pervasive, and objectively offensive that it effectively denies a person's access to a school's education program or activity. This means that students experiencing mild or moderate forms of sexual harassment will not be protected under Title IX unless the sexual harassment perpetrated against them becomes so bad that they drop out of school, drop a class, or are unable to attend their classes. This will force victims and survivors to endure escalating and repeated levels of harassment until the school is able to intervene. Second, the new regulations provide that schools must respond to sexual harassment that occurs in the school's education program or activity against a person in the United States. The new regulations narrow the definition of education program or activity to include only situations over which the school exercised substantial control and also buildings owned or controlled by student organizations officially recognized by post-secondary institutions. Consequently, schools could ignore violence and harassment that occurs outside of school, like online harassment as well as harassment that occurs in off-campus housing, even if it adversely affects a student's access to their education. Additionally, the requirement that the harassment is committed against a person in the United States limits the school's responsibility to respond to incidents only on American soil, which excludes study abroad programs. Third, the new regulations also require institutions of higher education to use a live hearing model with cross-examination to adjudicate formal complaints. Under this model, both parties are allowed an advisor who can be anyone, including an attorney. This means that survivors could be subjected to aggressive questioning by their perpetrator's parent, friend, fraternity brother, significant other, or experienced criminal defense attorney, which would be traumatic and work to deter the adjudication of formal complaints, pushing survivors into less effective informal resolution and mediation processes to avoid being subjected to this type of questioning. In the K-12 context, the live hearing model is optional so long as schools mandate written questions to and from each party. However, schools have the option to implement the hearing model and are more likely to do so if they are concerned about litigation over whether the hearing model is best practice. The model would be extremely traumatic and harmful to K-12 students. The aforementioned changes are just some of the many contained in the new regulations that will adversely affect victims and survivors' access to and success in the Title IX process. RMVLC's Title IX program has the resources to provide services to victims of gender-based discrimination in both K-12 and higher education settings. The Department of Education's blatant attack on survivors' rights in the Title IX process has not deterred us in our mission to provide services and advocacy throughout the Title IX administrative process. If you or someone you know needs help navigating the rule changes or the Title IX process, please reach out to RMVLC at 303-295-2001 or email us at info@rmvictimlaw.org. Thank you.